All right, we're going to take a trip back in time, all the way to 1953, for a legal battle over a pretty simple electrical device. Now, on the surface, it's a story about invention and ambition, but at its heart, it's really about a question of ownership that is, believe it or not, more relevant today than ever. And it all boils down to this one single, powerful question. When a great idea comes into the world, who actually gets to own it? This case really forces us to look at the huge difference between just being part of a team and truly owning the creation itself. So, our story kicks off in the early 1950s. We've got two inventors, Dolorito M. Feliciano and Maximo B. Tapinio, and they've created something they think has some real potential. What did they make? It was called the Fel-Tap meter garden detector. It was some kind of electrical contraption, and like any smart inventors would, they went straight to the patent office to protect their work and get a patent. Seems simple enough, right? Well, not quite. Because this is where the story starts to get messy. A third person, a man named Meliton D. Albaña, suddenly steps into the ring. He files a motion to intervene in the whole patent process, and his demands, well, they're meant to change the entire game. I mean, just look at this list. He's not just asking for a little credit here. He's asking the patent office to force one of the inventors to sign a contract, to compel them to get it notarized, and then, get this, to issue the patent with his name on it. Talk about a bold move. Okay, so here's the absolute heart of the disagreement. Albaña is claiming he's an assignee. That's just legal speak for someone who's been given ownership of the invention. But the inventors, they're saying the contract tells a totally different story, that Albaña was just hired as a selling agent to help them market their idea. This one disagreement is what the whole case is about. So Albaña takes these pretty aggressive demands straight to the director of patents. But the response he got, well, it shined a huge spotlight on a fundamental limit to what the patent office can actually do. What happened next was basically just a cycle of rejection. Albaña files his motion, and it gets denied. He doesn't give up, though. He files an amended motion, and boom, denied again. The patent office just wasn't buying what he was selling. But why? And this is the critical part. The reason they kept saying no is so important. The patent office didn't say Albaña was wrong. They said they didn't have the power to decide. Their job isn't to act like a court, to interpret some disputed contract and to force people to sign things. That's not their lane. So naturally, Albaña gets frustrated, and he appeals the decision. This moves the whole fight from an administrative office into a real, actual court of law. And now, for the very first time, a judge is going to look at the words in that contract and figure out who's really telling the truth. And there it is, a direct quote from the contract at the center of all this. The inventors themselves, Feliciano and Tapinio, put it right there in black and white. We are the co-inventors and joint 50-50 owners. I mean, it really doesn't get a whole lot clearer than that. They're explicitly saying the ownership is theirs. The court dug in a little deeper and found that the contract was really just laying out a business plan. The inventors had promised to sell their invention to a corporation, a new one that Albaña was helping them set up. It was all about a future deal, not a past transfer of their rights directly to him. So what was Albaña's role in all of this? Well, the contract said he'd be paid a pretty hefty sum for the time, 50,000 pesos. And what for? For his monetary and other helps. Specifically for organizing that corporation and drumming up investors. He was being paid for his services, plain and simple. So when you put all of that evidence together, the court's finding was crystal clear. This document was not an assignment of the invention. It was a service agreement. Albaña was a promoter, an agent, someone who was going to be paid for his work. He was not a co-owner of the idea. And this brings us to what is probably the biggest takeaway from this entire case. It's about a really fundamental principle in law, the separation of powers between an administrative body and a court. See, a court performs what's called a judicial function. It has the power to look at all the evidence, interpret a confusing contract, settle the dispute, and, most importantly, it can compel someone to do something. This separation is so crucial because it makes sure that these complex fights are handled by a system that's designed for it, a court, not just an office that files paperwork. Here's a perfect analogy. Think of the patent office like the DMV. If you go to the DMV with a car title that's all signed and ready to go, they'll record the transfer, no problem. But what if the seller refuses to sign? The DMV can't force them. For that, you have to go to a court of law, because a court can compel the sale. And so, the court's final verdict backed up the Patent Office's original decision completely. The Director of Patents simply doesn't have the judicial power to settle a contract fight or force inventors to sign away their rights. That power belongs to the courts, and only the courts. So if you remember just one thing from this whole story, let it be this. The Patent Office is a record keeper. It documents who owns an invention based on the papers you file. But when there's a real fight over who should own it, well, that's a battle for the courtroom. And that leaves us with one final question for today. You know, this case happened back in 1953. But in our modern world of startups, collaborations, and handshake deals, its lesson is more important than ever. So when you're working on that next big thing, just ask yourself, how clear are your agreements?